Hi, good evening. Well, it looks like Cedric Lofton has won a legal victory, sort of. Last week, the local district judge here uh, said that he felt that a jury should decide whether correction officers are at fault for Lofton's death. Now, Cedric Lofton, if you'll recall, was the 17-year-old juvenile who died at the hands of detention officers at the Cedric County Jail. So the judge had this to say after hearing evidence last week from both the defense and the plaintiff. A federal civil rights lawsuit will move forward against the 5 Cedric County correction officers who pinned 17-year-old Cedric Lofton to the floor of a holding cell until he went into cardiac arrest and died in September of 2021. Eric Milgren, the chief judge of the U.S. District Court of Kansas, denied the officers' petition to dismiss all claims against them, saying in an October the 3rd ruling that a jury must decide who to believe about what happened inside a small cell at the Juvenile Intake and Assessment Center. So what he's basically saying is that he's heard evidence and statements from both sides, and he's concluded that the real story is somewhere in the middle of what both sides are saying. So in other words, he doesn't believe all of what the plaintiff is saying, and he doesn't believe all of what the defense is saying. So he does what I consider to be the right thing: leave it into the hands of a jury. Now, in my opinion, this should have been the whole path for this trial, or it should have been set for trial by the district attorney back in September of 2021. But District Attorney Mark Bennett chose not to do that and not press any charges against, at that time, 5 Wichita police officers and these detention officers. He decided not to file any charges after hearing what I'm sure is the same evidence that this district judge heard. And see, ladies and gentlemen, this is the difference between someone who is acting as a legitimate prosecutor and a prosecutor who's in the bed with law enforcement. You see, as long as I can remember, the only law enforcement officer that Mark Bennett has taken to trial was a Black police officer who fired a shot inside a home, and the shot ricocheted off the wall and killed a dog. And Bennett filed charges against this officer, the only one. As a matter of fact, there was another case involving a white officer who fired a shot inside of a home. It ricocheted off the wall and hit an occupant of the house who was white. And Bennett didn't file any charges. As a matter of fact, I distinctly remember that when this case went before the state legislature, one of the legislators asked, why is Mark Bennett in such a rush to file charges against a Black officer whose bullet ricocheted off the wall and killed a dog, but yet he refuses to file charges against a white officer who fired a shot that ricocheted and hit a white occupant of the home that he was in. So this has been the history of Mark Bennett. He's never seen a case against a white officer killing a Black youth, unarmed, by the way, that he didn't love. All right? So now let's move on. Now, Milgren, a video camera in the lobby of the detention center captured the struggle between Cedric Lofton and these detention officers. But the view of the officers and Lofton is obscured by the cell door and the angle of the camera. No audio was captured. A jury trial is scheduled to begin on December the 3rd of this year and is expected that there will be an appeal to Melvin's decision by the county officers. So if that happens, there's an appeal filed, then this trial will be set back until the appellate court can render a decision whether or not they will take up the case or not, or remand it back to the district court judge here. So we'll have to wait and see. But on the face of it, it looks like this judge has taken a position that would be in favor of Cedric Lofton going forward. Now, the 5 juvenile correction officers, and they list their names here, and I'm not even going to mention those, have said that they did not apply pressure to Lofton's back or neck as they held him down in the prone position for more than 40 minutes. They have said they continued to pin Lofton to the ground because they feared for their safety, and their lawyers argued that it was Lofton's own resistance that caused his death. Now, here's the problem with this, and here's where the judge says, let the jury decide, because look, this is almost impossible, what this lawyer is stating. Because let me tell you this, medical experts in Lofton's legal team said the video shows the officers had control of Lofton and he stopped resisting within 5 minutes. Now remember, there's 5 officers. Forensic evidence of blunt force trauma to Lofton's back and neck area suggested the officers used significant force to cut off Lofton's oxygen supply and ultimately killed him, the court records show. So how in the hell could this man, if he stopped resisting after 5 minutes, okay, 5 minutes, and they still held him down in a prone position, and I don't believe this, that they don't have no pressure on the man's back or neck. I don't believe it. If they figured that he was so strong, okay, that he was a threat to 5 officers, I'm not convinced that they didn't use excessive force, ladies and gentlemen. Unnecessary excessive force. Okay? Now, realistically, the truth lies somewhere in the middle. This is what the judge says, okay? So it seems obvious to the court from the video footage that Lofton was subdued after the 5-minute mark, yet it is also clear that time, even acknowledged by the defendants, that during which non-movement occurs, specifically, defendants list various times they claim Lofton's resistance is visible on the footage. However, there was no resistance from timestamps 29 minutes and 23 seconds to 41 minutes and 45 seconds. Okay, so that right there is an out and out lie. Okay, it's contradicted by the video footage. Now, Melgren denied the officers qualified immunity for excessive force charges, saying that the question of the officers, and I don't know how you got this, saying the question of whether the officers had sufficient control over Lofton to safely move him out of the prone position is material to the question of not whether, and I believe it will say, whether the continued use of the prone position constituted excessive force and must be decided by a jury. Okay? So there's a total contradiction here. Now, Melgren also said the video evidence of the officers pinning Lofton is inconclusive regarding pressure applied to his back. The court cannot conclude that the officers' conduct was extreme or outrageous without resolving the preliminary questions of whether the officers placed significant pressure on Lofton's back and whether Lofton continually resisted restraint, Melgren reported. Now, I'm going to just tell you one thing. Now, not only does the video show these guys are lying, all right, but I'm going to go read a little further, and we'll see that the coroner and a private coroner that was hired by the family, after viewing the evidence and looking at his body, they contradicted these officers. Okay, listen to this. Cedric County's legal team argued that 5 employees were entitled to qualified immunity. Now, this is the way they usually get off, ladies and gentlemen. Okay, they get off by the district attorney saying that, hey, he's not going to file any charges because qualified immunity basically permits them to do dadgum near anything and be found innocent, or innocent of excessive force, okay, or innocent of conduct unbecoming a professional officer. All right. So Melgren did dismiss several claims, including negligence to serious medical needs, but he declined to issue similar claims, not that the officer used excessive force against Lofton, intentionally inflicted emotional distress, engaged in extreme and outrageous conduct, battery, or failed to intervene and possibly save Lofton's life. They didn't do any of that. Okay? They didn't do any of that. Yeah. It wasn't a complete win for us, but it was a substantial win, said Stephen Hart, one of the attorneys representing Lofton's brother, Marquez Teets. It's a near complete validation of our claims, Hart said. The judge really got it. He understood that there are issues in dispute, and he recognized and endorsed our right to have this case tried to a jury of Lofton's peers. And that's where it should have been all along. Okay? Now, I want you to understand this. The only remaining claim in the lawsuit are against the 5 county officers. Melgren previously dismissed the case against the Wichita police officers who brought Lofton to juvenile lockup, as well as Cedric County and the city of Wichita, which were originally named as defendants. Now, listen to this. This is important in my view. Since February of 22, the county has spent $733,307 $733,307.87 on legal expenses fighting Teets' lawsuit. Spokesperson Nicole Gibbs said she declined to comment further on the active litigation. Now, this is fast approaching $1 million in attorney fees that they would spend fighting this lawsuit. And it's not over yet. And if the appellate court decides to remand this case back to the district court, it's going to be a jury and a jury trial. That's going to cost even more money. So the charge here could very well add up to $1 million+ for legal fees for the county. That's your tax paid, your tax dollars. Yours and my tax dollars are going for this. Why in the hell wouldn't they just fess up, admit they made a mistake, okay? Admit that this kid lost his life based on actions that the county employees, detention employees in this case, they imposed upon this young man, 17 years old. Look, this kid didn't weigh 175 pounds. And you got 5 officers that have this man handcuffed behind his back. And they can't hold him, and he's on his stomach. All right? Now, what kind of fighting can he do? How in the hell can he be a threat and have them fear for their safety in that position? It baffles me. All right. Now, listen to this. The Cedric County Medical Examiner's autopsy report determined that Lofton's death was a homicide from complications of cardiopulmonary arrest sustained after physical struggle while restrained in the prone position. Now, listen to this. The report completed by Chief Medical Examiner Timothy S. Gorell also noted several signs of blunt force trauma on Lofton's shoulders and back, including bruises and abrasions in the middle of his upper back and in the middle of his back when he examined the teen's body on September the 27th, 3 days after Lofton went into cardiac arrest and 1 day after his death in a Wichita hospital. Now, how the hell did he get those injuries? Bruises and abrasions. How did he get that? And yet nobody applying any pressure. They didn't sit on applying any pressure to his back and his neck, they say. All right? So listen to this. Jane Turner, a forensic pathologist hired by Lofton's lawyers, viewed photographs and reviewed Gorell's findings. She also examined Lofton's body on October the 20th, 2021, and found extensive hemorrhaging of his back and shoulders associated with cutaneous injuries documented in my and Dr. Gorell's examinations. She found that the most severe injuries are located at Cedric's shoulders and back with extensive acute hemorrhage. How did that happen? The man is lying on his stomach. How did he obtain these injuries to his back and neck? Only at the hands of these officers. 5 of them, remember, but they say we didn't touch his back. We didn't sit on his back or neck. We didn't put any pressure on his neck and back, but we just held him down. Well, hey, does it take 5 officers to hold down a 17-year-old who weighs less than 175 pounds? It takes 5 officers. He's handcuffed behind his back, and it takes 5 officers to restrain this guy. And you also have him in a restraint, a full body restraint. I don't understand it. The presence of injuries to Cedric's face, head, neck, shoulders, and back is consistent with the JIAC/JDF officers having applied significant force to his body while he was in a prone position for an extended period, Turner wrote in a report that has become part of the court file. Based on my review of this incident, it is far more likely than not that the extensive hemorrhaging in Cedric's back and shoulders were the result of such significant force applied by JIAC and /JDF officers. It is my opinion, within a reasonable degree of medical certainty, that the cause of Cedric Lofton's death is prone restraint with cardiac arrest. Okay? Now, here's the part that I think you'll find interesting. Those findings, now both by Cedric County coroner and the private forensic pathologist that was hired by the family, come to the same conclusion. But listen to this. Those findings contradict the findings of Cedric County Bennett, who declined to pursue criminal charges against homicide. Now, why in the heck would he do that? He didn't conduct a complete investigation, in my opinion, okay, in this entire case. He never fully investigated this. He didn't wait for the coroner's report, and he didn't even put any confidence in the coroner's report when he received it. He made the decision on his own not to file any charges against these officers. A 17-year-old, unarmed, black kid, not resisting, was killed, murdered by Cedric County detainees. Okay? And yet he doesn't want to file any charges against anybody because he feels that, hey, they're entitled to qualified immunity. All right? Bennett wrote that he would not pursue involuntary manslaughter for the county employees because they said they didn't lay on Mr. Lofton, even though video evidence was inconclusive. So he didn't give Mr. Lofton the benefit of the doubt. These officers said to him in conversation that was contradicted by 2 pathologists here, and Bennett chose to believe the officers. Okay? Something's wrong with that picture. But that has been the pathology, the MO of Mark Bennett ever since he's been in office as a district attorney. Okay? Now, it does not appear that any of the officers laid directly on top of or placed their weight on Cedric's back/torso. Bennett wrote in a report on his decision not to file charges. Mr. Bennett, did you look at all the evidence, or you made your decision based on your opinion and your association and your relationship with said officers? That's the question, sir. Had anyone put their full weight on his back/chest for an extended period of time during the struggle? It's hard to imagine Cedric could have remained conscious and struggling for 35 minutes. And in this case, it was 40 minutes. Bennett continued. The lack of significant blunt force injuries located during the autopsy to his torso, back/chest, and the presence only of minimal abrasions and contusions further diminishes such an argument. Mr. Bennett, you didn't do your damn job. It's as simple as that. Holding someone by the arms and lower legs while the person struggles does not establish an unjustifiable risk sufficient to prove reckless means element under Kansas law. Milgren, the federal judge, said a jury should ultimately decide the question. The doctors conclude that these injuries were indicative of significant weight or pressure being applied to those areas of Lofton's body, Milgren wrote. Specifically, the doctors opined that such presence contributed to the development of Lofton's cardiac arrest, which ultimately caused his death, Mr. Bennett. By contrast, the defendants say that none of the officers applied significant pressure to Lofton's back or arm. So how in the hell did he get the bruises and the abrasions? How in the hell did he lose his supply of oxygen? Tell me. How did that happen? Specifically, they claim that Newby's and Buckner's SAFE holds involved them lying to Lofton's side without putting their body weight directly on him. I mean, that is so ridiculous that it's even beyond funny. Further, defendants argue that as Conklin kneeled on the floor, she placed her hands on Lofton's hips to prevent him from standing up, but did not lay her weight across his back, Milgren wrote. This is the judge. The judge wrote that the dispute over how officers restrained Lofton could influence the outcome of the lawsuit, and that because a rational jury as opposed to a rational district attorney, could find in plaintiff's favor on such evidence. Summary judgment dismissing the excessive force claims and other related claims would be inappropriate. That's from the judge. And that goes straight to the district attorney, Mark Bennett. I want to read that again. Summary judgment dismissing the excessive force claims, because this is what Mark Bennett claims. There was no excessive force used. So dismissing the excessive force claims and other related claims would be inappropriate. So that means it was inappropriate for you, Mark Bennett, not to file charges against these officers and send it to court and let a jury decide. But no, you don't want to do that. You want to use your position as an authority, as the district attorney of Cedric County, to protect the very officers that you have a personal relationship with. Milgren also denied defendants' request to dismiss claims that they intentionally inflicted emotional distress on the team. Attorneys representing the officers contend that because Lofton was already experiencing a mental health crisis, plaintiffs would need an expert witness to opine on how Lofton's distress worsened at Giant. Because of the deadline for designating expert witnesses had passed, they argued the claim should be dropped. The judge disagreed. Frankly, the court is uncertain that requiring an expert to testify on causation would help the jury reach a conclusion that it would otherwise be unable to reach, the judge wrote. It does not take a medical professional to understand that enduring the physical force of 4 adult officers to the point where the mind goes unconscious and the heart stops beating would induce significant mental and emotional distress throughout the 40-minute process, regardless of a pre-existing mental crisis. That's from the judge. So, all in all, this judge is fed up with the shenanigans that was brought to him in his courtroom by the district attorney and the defense attorney for these 5 Cedric County detention officers. Okay, and he did, and what in my estimation, in my consideration, is the right thing. Send this to trial to a jury. Let them make the decision after hearing and weighing all of the evidence, not just from one side, as apparently Mark Bennett did. So again, I say this is a victory. It's not justice, but it's a victory that could lead to justice for Cedric Lofton. We'll have to wait and see. And if the appellate court refuses to hear this, this case could go to trial sometimes in December. Yeah, so we'll have to wait. If they do agree to hear it, it could be maybe next June before it goes to trial. We don't know, right? But I'm just glad to report here to you all that as of right now, this thing, the pendulum has swung back in the favor of Lofton's brother and family, okay, by sending this case back. I'm up for jury trial. Let's hope it stays that way, and let's hope that it works out in their favor. It is time for Mark Bennett to start doing his job and doing thorough investigations after hearing both sides of the argument against these killings of unarmed young Black men. Okay? All right, that's my show. Thank you very much for watching, and we'll see you next time.